So Stephanie, over to you.
Thank you. Thank you very much, Vinu. I appreciate it very much. And yeah, my PowerPoint is, it's very much an outline. So feel free to follow along as you like. Certainly, though, I know that in these COVID times, visual stimulation is, it seems like we're staring at screens all the time. So also feel free to, if you want, you don't need to look at the PowerPoint. You can rest your eyes for a little bit and we can have a discussion. Yes, I am a sole practitioner. I represent parents and guardians dealing with child protection matters. I represent folks in FLA matters as well. And we will just dive in here. I'm on the traditional and unceded territory of the Comox First Nation right now. And when I put the presentation together, I sort of went through my history as a human being and where I come from and where I've lived. And I realized that the territories, the First Nations, the Indigenous communities, the land that I've lived on is, it's vast. It is so vast. It goes coast to coast on here on Turtle Island. And certainly since 2013 being on this chunk of rock that we call Vancouver Island now, so-called Vancouver Island, it means the world to me. And it's such a privilege. And I recognize that who I am now and what I'm doing now would not be possible were it not for the privilege of where I am. So certainly, please do take a close look at my slides. I am truly grateful to all the First Nations, Métis, and Inuit folks who have allowed me to walk beside them especially in their dealings with the ministries of children and families and designated Aboriginal agencies and the court system. So here we are. I welcome your questions very much. Vinu is going to help me out by facilitating questions. So if you have any, please do put them either in the chat or the question and answer, and we will get to them as it makes sense to do so. You can also, of course, my email address is at the front and the end. If you want to email me about anything specific or give me a call, please feel free to do that. My website's also up as of yesterday, if you want to learn more about me. We're going to be having some breakout sessions throughout, and about the halfway mark, Vinu's going to let us know when that is. And we'll do a bit of a stretch just for a couple minutes, because I know, again, sitting in a chair for 2 hours is a challenge for me, certainly, and I respect that. So thank you. Thank you all for being here. So why? Why are we here talking about this? Why are we here talking about this? To do a number of different things. I'm very cognizant of the need to center clients and their experiences when they're dealing with the law system, certainly, legal system. It's important to me that we being lawyers recognize that we're not at the center of this process. The clients have to be at the center. And that's why it's so wonderful to have such a strong community of advocates working in this system, because without community, it's very easy to feel disconnected, and especially during COVID. So I'm very happy to be here presenting to you, certainly. And also because the role of lawyers can be quite limited, both in the time available to them. I've had no private child protection clients. They've all been through legal aid referrals. And I've had one, maybe two inquiries from folks who wanted to pay privately for child protection law services. And for whatever reason, it just never panned out. So we can, as lawyers, we're very limited with the legal aid tariffs. And if you haven't taken a look at them, they're on the website, legal aid's website. Check them out, see how much time we have available for certain things, for sure. But advocates are so very valuable in your unique role, being able to fill the gaps that are left when lawyers engage in the legal system, the child protection system, with their clients. And honestly, I'm a member of one of the committees on the Association of Legal Aid Lawyers. And just last night, I was telling the community that if I was in charge, every client who was provided with a legal aid referral would also get access to an advocate for preferably unlimited amount of time, but at least a set amount of time. And I know that with the recent changes to Legal Aid BC, I'm very optimistic that the changes that have happened will mean that there are some additional positive and meaningful supports to clients of all of the legal aid lawyers out there. So that's important to me. So you're aware, I'm based here in the Comox Valley, but I practice in Courtenay, Campbell River, up in Port Hardy and Port McNeill, over in Port Alberni. Right now I've got files in Duncan. I'm talking to some folks in Powell River. I'm sort of all over, and it's a unique experience because I am able to practice both rurally and a bit more in more urban settings. And I do have experience certainly in Victoria. I was the managing lawyer of the Parents Legal Center in Victoria when it opened. We opened it up. I had a role in that I'm very proud of, and was there for about a year and a half. And for me, I found it fairly limiting not being able to take matters to trial, knowing that if a client wanted to fight something and a trial was being set or a contested presentation hearing was being set, I would have to send them to a different lawyer. So being back in a more holistic legal role is it's the best fit for me. So I'm very happy to be here. And I do some Family Law Act representations as well. Usually they come out of my child protection files. So at the very least for the Vancouver Island and Sunshine Coast, I feel like I've got a decent handle on how things are going and how different they are. Certainly when we can move over to my next slide here. Oh, maybe not, just one moment. Certainly the differences between practicing in Courtenay and Campbell River and then comparing that to the situation in Port Hardy, where the MCFD office is incredibly understaffed. They are lacking social workers all the time. And it can be sometimes a real challenge to know that there are services in the more urban areas that just aren't available to clients in the more rural areas. And that's oftentimes where advocates come in, certainly to help to bridge that gap a little bit. So yeah, okay. And just the last point here on this slide, acknowledging the realities of the child protection systems that clients experience. Certainly that's part of it. Just being aware of each location's limitations and advantages, of course, it's not all bad, is important, and advocates are so important there as well. And in making sure clients' voices are heard, and we'll talk more about that. I know that there have been trauma-informed practice is very much the buzzword of the legal community, the helping professions lately. And I think that because advocates are the community builders of the legal world, that it's so important that I think that we're all on the same page regarding things like trauma-informed practice. And just the basic tenet that, no one's ever going to know what a client's dealing with truly in their history, their experience, their concerns, their background. And with the limits placed on the work that we do, and I mean time limits specifically, it's not likely that any of us are going to hear the full story from a client. And I mean, it may be that the client is never going to be able to tell their full story, certainly. Trauma-informed practice is something that has been on my mind for quite some time. I was involved in a couple of positive space campaigns on university campuses in the 90s. So it's been a while. But the idea there was that safe spaces were being created, specific safe spaces, and trauma-informed practice brings the concept of positive and safe space into the wider world, into the world at large. And the reason that I think it's so very important in this work is that if a client can assume, if they just inherently are aware that they will be safe with a lawyer, with an advocate, with other service providers and supports, that trust will build. Generally, trust will build faster, relationships can get stronger faster, and you can get to the point where it's easier for clients to share information, which is so important, especially in child protection situations, because sometimes the information that we need from our clients, lawyers and advocates both, is the information that's the hardest for them to share. So that's why I think it's so very important. And there's a bit of a quote from this trauma-informed practice principles. We'll talk about it a little bit more in a couple of slides, but the last thing I would say just at this point is that lawyering is a very conservative profession, and that's across the board, right? It's no matter how right on, how left-wing progressive a lawyer is, they're always dealing with a very regimented, regulated professional framework, let's say. So it can be frustrating, certainly for anyone, myself included, lawyer. I feel that I do my best to be trauma informed. It can be very frustrating dealing with other professionals where either they don't have the education, they haven't sought out the education about trauma informed practice, or where the commitment to trauma informed practice isn't sincere. And I mean that from both an individual standpoint, but also organizationally. Certainly, when advocates and lawyers are in a workplace where they are committed to trauma-informed practice, but the workplace isn't, the executive isn't, management maybe pays it lip service, but that's it. It can be very difficult to create those spaces of safety. And certainly in terms of lawyers and advocates, we're also dealing with clients who likely would have had no reason to be educated in terms of trauma-informed practice. So, and that can have a very negative effect on their child protection matters. I'm thinking specifically about cases where trans youth have sought legal assistance not legal assistance, but assistance from social workers. And then the situation turns into a legal situation where one of their parents or both of their parents, any of their caregivers, their guardians, refuse to honor their truth and may respond negatively, may respond violently. I'm also thinking about children dealing with physical conditions where a parent or caregiver may insist that the condition they're dealing with, be it medical or ADHD, autism, parents thinking that behavior is laziness or attention seeking, when really it's part of the way that they live their lives. These children, they're not going to get away from experiencing living with ADHD or being autistic. So it's little things like that where we need to be, lawyers and advocates all need to be aware that sometimes that's part of our jobs. We have to educate on why it's important to be open to honoring the experiences of children and also the experiences of the other parent, for sure. So other examples of, things that I realize cost money, but would be a huge benefit to making spaces safer, more accessible, accessible entrances, spaces, ramps, big enough to fit a full-size motorized wheelchair and also a large stroller, and also chairs of all sizes without arms on them for folks of all size, for sure. Yeah. So I think we've touched nicely on that. Okay, so as a more practical tip, I think that it's 2021 and most lawyers, even if they're not educated in it, are aware of what trauma-informed practice is. And so I think all of the above is my long way of saying, if you're not sure as an advocate for your clients, or just as an advocate who's curious, if you're not sure about a lawyer's stance on being trauma-informed, ask them. And I think that this is a good thing for an advocate to consider doing without the client present, because it takes the pressure off of the client. It's less chance that an interaction is going to reflect negatively on a client. Just advocate giving a call to the lawyer and saying hi and seeing how they do things. It's also possible to do it with social workers, for sure, if there's an opportunity there to do that. And I know, I've certainly, as a lawyer, had conversations with social workers outside of specific client interactions where, just saying, letting them know that maybe using words other than clean or dirty to describe whether a client is using substances, actively using, right? Human beings aren't clean, they're not dirty, they're people. Referring to someone as dirty because they're using drugs, that's not trauma-informed. Language choices, choosing between, instead of saying problems, concerns, issues, points to deal with, stuff like that. And I mean, if it comes to it, if a client and a lawyer truly can't see, eye to eye on trauma-informed practice, you can always ask for a new lawyer to be appointed. Sometimes it doesn't work out. Sometimes it's better to stick around and work with the person you've got, but that's an option as well, for sure. Okay. So I think it's very important I do a lot of reading. I'm a big reader, and I don't practice environmental law, but certainly I think there are a lot of similarities between environmental law and child protection law. Anything that has to do with where there's a high concentration of Indigenous folks involved, certainly we need to pay attention to the land, right? Vino and I have both, we made it very clear we know whose land we are on, and I'm fully aware that it's a huge privilege to me to be here. I was not invited. So it's also important as a legal professional, and I mean, the second slide here makes it clear, we must sit with the uncomfortable truth of how our education, health, and legal systems have harmed and continue to harm generations of Indigenous families through residential schools and continued systemic injustice, and that includes through child protection systems, certainly. So my role as a lawyer is always going to be problematic, no matter how trauma-informed I am, because of the systems that we're working with, because of the very conservative nature of the legal profession, and because of what the legal profession has done in terms of creating laws, and that not just criminal laws, certainly, but the laws that have to do with child protection law, family law, property, so on and so forth. So that I'm constrained in the legal advice that I give to my clients based on flawed legislation, that's always going to be a problem. I work in the area because parents need to be represented, and represented well, when their liberty is at stake. And by that, I mean their ability to parent their children without the unnecessary interference of the province, social workers, the director, whatever term you want to use. I think it's very important that we recognize, though, that this is the beginning of a bit of a shift, because for so long, and even not that long ago, the education that I received about things like residential schools in the 60s and 70s scoop, they were taught as though it was the history of Indigenous people, as opposed to the history of, and in my notes, I have mostly in brackets, but white people, right? And other people complicit with these systems. So I think it's no longer appropriate to just say that Indigenous folks had things happen to them, right? Residential schools happened. We need to name who did these things and who let them happen, and then we'll be able to move on to true and positive change. We're not quite there yet, clearly, because the systems are still so flawed. However, I'm optimistic, and your roles as advocates is part of how I can be optimistic, certainly. And I'm looking at the time and I realize we need to move a little bit faster, or we're never going to get to the end here. But yeah, maybe I should, I don't know. I have a really fancy microphone here that you guys can't see, but I'm thinking podcast might be time. You can let me know in the comments if you think that's a good idea, but certainly we're dealing with a very heavy area of the law. So when possible, if we can keep it light, I mean, it's good to do that. However, we can't deny that. Oh, thank you, Sarah. Joyce. Oh, sorry. I said I wouldn't. I was told not to say people's names. My apologies. It's just that I know who those people are. Thank you. I appreciate your enthusiasm. So as I was saying, oh, now I'm all thrown off because enthusiasm has been returned to me. See, this is why a dialogue is so much more valuable than just me talking into the void and the cave in which I practice law here. Okay, so I was talking a little bit about liberty, families with their liberty at stake. It's important to know that child protection law isn't, I want to say it's not family law. It's not just family law. It's family law plus, let's say, because it always involves families, but it also has aspects of administrative law, and by that I mean that social workers have a huge amount of power to make decisions. And when they make those decisions, judges are often very hesitant to comment on them or interfere with them. I'm speaking specifically about when social workers place children either with caregivers known to the child or foster parents. But it does sometimes occur. And certainly we'll talk a little bit about a victory in that regard later on. But I'm sure every advocate of really everyone who's dealt, every human who's got a person in their life who's dealing with or has dealt with the child protection legal system knows that it's very easy for a parent or guardian to feel like they're being punished by the situation they find themselves in. And this is especially true when the parent has reached out for help. And with that help comes an intrusive role of the state, essentially. I can think of examples of people who have reached out because they needed support for groceries or income, or the other parent is abusive. And so they've reached out for support and they're the protective parent. And then it feels like they are under the great scrutiny because they're being told they have to keep their children safe from an abusive partner. Or when families need additional support, when they've got members who are disabled or autistic or ADHD, things like that. It can feel very much like parents are being punished. And then, of course, the standard of proof we're dealing with is not, though, the criminal defense standard of proof beyond a reasonable doubt. That's not where we're at. And it's not even balance of probabilities, which is the usual civil standard, the family law. If you're dealing with FLA, balance of probabilities, which is the judge kind of going, if it gets to a judge, I'm more than 50% sure a thing is either true or is in the child's best interest. Social workers are able to make decisions based on likelihood. Just something is likely that it happened or may happen. And that can be very difficult to express to clients, certainly. And sometimes that's where I look to the advocates that I'm working with to say, listen, let's you and me have this conversation. And then if you can translate Steph, the lawyer, into a language that your client will be receptive to, I would find that just such a benefit to my ability to express where we're at, because it's not fair. It's not. It's certainly not. You reach out for help, and then all of a sudden you've got intrusive intervention. That's not fair. But it's the system that we find ourselves in. And certainly in situations where clients have been either under an investigation by law enforcement or charges have been laid, but no conviction has been made, social workers have the power to act on likelihood and go, well, even though a judge wasn't going to convict you, we figure it did still happen. So the power imbalance is what makes the role of advocates so very important, specifically in child protection law, but in the legal system at large, because without adequate support in dealing with how unfair this stuff is, it can be so hard to stomach for clients. So that's another huge benefit to having advocates present. And I say thank you to the person who loves the statement reconciliation as a verb. It's not mine. I could not tell you the first time I heard it or saw it, but I say it a lot because it is. I was on the phone with another lawyer just right before the session started, and it came up because it's so very important. So very important. So this is, I've chosen this example on this slide, and it's a poor example. I've chosen a poor example on purpose because this comes from the federal government of Canada's website. This is what was on last week. They're using census data from 2016 and showing, sure, it's a big number. Of course, 52.2% of children in Canada in foster care are Indigenous. They account for only 7.7% of the child population in 2016. And then they provide the numbers. It's a stark statistic. I don't think it's useless, but it certainly doesn't take into account families dealing with the system where children are not in care. It doesn't take into account children in out of care arrangements, right? That's just foster care. It's not extended family placements. It's not voluntary care agreements. So it's not a full picture. And it certainly does not, there's no trauma-informed lens applied here, right? If there was, it would be bigger information. And this is on the main website. Like if you go to that tiny URL, you will go to the main Government of Canada website for Indigenous children in care. It's not hidden. It's very easy to find. So it also, I invite you to take a look as an example of an unhelpful resource because no solutions or strategies are provided. And we'll talk a bit more about the TRC calls to action in a moment. But it's important to notice that the changes we're seeing in the legal community, although slow, are not nearly as slow as the changes we're seeing in government, unfortunately. So that's where we find ourselves. I think here, let's go back before we look at that one. I think it's important to note that trauma-informed practice means recognizing that so many things that in the past have not been seen as trauma responses are. And the big example I'm thinking of is addiction. If anybody knows the work that Gabor Mate has done, he worked for decades, still does, I believe, on the downtown east side of Vancouver. And his work, he's written a number of really great books. You can check them out. Also, family violence is also very much seen, the perpetuation, intergenerational perpetuation of family violence. Certainly, it's both trauma creating and a trauma response. And I can think of a number of clients, vast number of clients who are traumatized by the fact that they have a low literacy level. They're just, their reading level is not at a high school or even junior high school level. They're reading at an elementary school level. And so that's why it's so important to meet folks where they're at today and assist them in moving forward, because it's not something I often say to my clients, but I often say it to their supports. I say it to the folks in my family a lot and my friends, is that there are no time machines yet. We can't go back in time. So what we can do is meet folks where they're at and help them to make, hopefully, the choices, the plans that will help them to resolve the concerns and get the social workers out of their lives. Because social workers can be really great, but most people don't want them all up in their business. So that's where it is. Oh, and just as a last note here, I'm just seeing in my notes, this is very important. I know every lawyer who does legal aid work knows that Advocates Talk and your network of information is fantastic. And so I'm always looking to add services and supports to my referral network. I'm always looking to add other lawyers, because I have advocates who call me and ask, do you know somebody in this area? Do you know someone? I've got a client dealing with this specific concern. Do you have a lawyer who has information about that? So if any advocates out there think there's somebody I should know that I don't already know, please let me know. I'll call them. I'll say hi. It's always a good thing, I think, because honestly, seeing a lawyer is hard enough. Having kids removed, threat of removal for parents, for entire families, it's hard. It's harder than it needs to be. And it's made even harder without entering and, without, it's rather not knowing whether or not the lawyer you're going to deal with is trauma informed. Just it's an added level of difficulty that doesn't need to be there. So that's where I was going with that. I do see a question. I'm just going to take a quick read over here. Okay, so it says, I feel like out of care arrangements are super common to keep those statistics at where they are instead of where they would be if they weren't convincing people to agree to these out of care options, in quotation marks. I've seen it a lot in my life. Thank you for that. Yeah, sure. Certainly. I think that not including the out of care options keeps the numbers down. Most definitely. That's a really great observation. Thank you for that. Okay. Lawyers need and benefit from your help, advocates. I am very grateful that you are here. And I should say that this is not a photograph of mine. I don't know these people. I don't know how that advocate and that lawyer got there on that cliff together helping each other, but here we are. The lawyer, of course, would be the wet blanket of the professional world. that is how I describe myself every time I go into, in my head at least, every time I go into a conversation where I'm going, it is literally my job to ruin your day with the information I'm about to give you. Maybe I've received a fax and it's a new set of court documents where we were expecting a certain order to be extended and a CCO, continuing care order, has been applied for. Maybe I've had a conversation with a social worker and the social worker says, we've received a report from our CMP about your client and here are the details. And I have to tell the client what that means. And maybe they're not going to get to see their kids for a little while until social worker investigates. So yeah, professional bearers of bad news, certainly. Trauma-informed lawyering is this awareness of the effects of delivering this information to our clients, where the information is legally relevant, but we know it has the capacity to be trauma-invoking. So that's just part of why we need your help so much, is because of that, essentially, because we're the wet blankets of the professional world. Yeah. Okay. So I talked a bit more, or a bit above earlier, about how my role as a lawyer is problematic. And looking at these principles of trauma-informed practice, and again, that's from that TSG resource, Trauma, Gender, Substance Use, from the BC Women's Hospital. And there's a link to it, I think, on the next slide if you'd like to take a closer look. But the 4 main points: trauma awareness, safety and trustworthiness, choice, collaboration, and connection, and strengths-based and skill building. Where there is a deficit for lawyers, for me as my role as a lawyer, is certainly safety and trustworthiness. I know that most, I'm not going to say all, I've certainly had I've had a number of clients who I've had a really nice connection with. And I feel from what they've told me, and they've shared with me, that they felt that they had shared, they'd opened up truly with me as their lawyer. However, that's not the case generally. And I have to go into working with my clients knowing that oftentimes there's nothing I can do or say, because I am a lawyer and I'm their lawyer, that will inspire them to trust me. Your role as advocates is very unique because you don't have to be the bearers of bad legal news. Certainly sometimes if I can't find a client and I have a consent agreement in play, or a consent in place with the advocate, I'm permitted by my client to tell the advocate what's going on. Sure, sometimes it can be you telling the client the legal news they might not want to hear, but generally I try to keep that role for myself, because I want to keep you as the client's advocate in a supportive role, not in an informational, potentially negative informational role. And I think about things like that I would want to tell my clients that just wouldn't come off very well with me saying them. One of them is telling a client who's a parent and has been for many years, whose children have been apprehended by social workers, perhaps RCMP has been involved, traumatic experience for everybody. Me telling that client that having their kids in care is an opportunity for them to rest, get their house in order. I mean, both literally and figuratively. It doesn't go over well. I probably tried it once or twice as a junior lawyer and realized quickly that no client wants to hear their lawyer saying I'm a very literal person. When I say things, I mean, generally, unless I'm clearly joking, I mean exactly what I'm saying, with no subtext, nothing else going on. But I understand that most people, if they heard their lawyer tell them, oh yeah, your kids are in care, what a great opportunity, I understand it's not going over well. I thinking back on the fact that I've done it, I feel great shame and minimal shame. I've worked on the shame, but I certainly am very glad that I've learned and educated myself, and I don't do that anymore. However, I think that it's the advocates the role is so valuable because you are able to develop a more caring role, a more supportive role. And so maybe if you're having tea with your I never have an opportunity to just sit down and chill and have a cup of tea with my clients, unfortunately. And but if you do, being able to, in the course of a conversation, it comes out organically, listen, maybe take this as take the rest that you need. If you've never checked out the NAP ministry online, on the social media, I suggest you do. It's really rather fantastic. And the concept of rest as a divine right is something that speaks to me as somebody who, for a lot of years, had to be told it was okay to rest. And I know that in the helping professions, certainly, that's our jam, all of us. We find great value, great meaning in the work we do, so it can be tough to take a break. I also suggest there's a really great book. It's so wonderful. It's called Laziness Does Not Exist. It's by a scholar named Devin Price. And just these concepts, right? Like if you need to read a book about it, go for it. But just the idea being that as an advocate, you're better suited to guiding the clients in these ways. So certainly a lot of legal advice is contraindicated to rest, right? Like when I'm telling my clients they have to do X, Y, and Z for the best chance to get their kids back, it's the opposite of me telling them that they should, go take a night off. And certainly in my experience, I've got a question. Which ministry? The NAP ministry, NAP, like go for a nap ministry. Go check it out. It's very cool. So yeah, clients can feel guilty for taking breaks just like anybody else, right? We feel like sometimes as humans, we feel like we haven't done enough. We don't deserve a break. And certainly any client whose kids have been removed, they've already got literally somebody telling them they haven't done enough, right? You haven't done enough to have your kids in your care. So for sure that messaging is already there. But of course, human beings need rest. And having kids in care, oh, thank you. That's fantastic. There's a link. Having kids in care can give parents or caregivers the opportunity to attend treatment, to attend I'm struggling with a word other than residential for what kind of treatment it is, but the kind of treatment where you go and stay there, given the negative connotations of the residential word, right? Treatment not only for substance use concerns currently and addictions, but also there are a number of trauma treatment programs. Certainly there's lots that our clients, legal aid clients with the income cutoffs, they will never be able to afford to pay for privately, but there are some funding options. First Nations Health Authority, they have a number of, right now, I'm aware of a few online programs for folks through different agencies. It really depends on what's available. We, as advocates, so much better than I do that programs come and go, and whether one will be available to a client is hit and miss all the time. But so whatever's available when your client's at the place to attend, the place in their life, I mean. And having children in care, it can be an opportunity for the parent to focus on themselves in a way they've never done before. And especially true if the client became a parent at a very young age. So all of these things are things that me as a lawyer saying will never land with clients, or they probably won't, but more opportunities for yourselves as advocates, certainly. So here are some resources. There's a link to the trauma-informed practice principles. The province of BC has put out trauma-informed practice resources. So there's, changes is on the way, even if it's coming slowly. MCFD publishes online their trauma-informed practice guide. So you can see what social workers are supposed to be aware of, and hopefully are aware of. And then finally, on October 4th, Miriam McCallum, who is a lawyer and a fantastic speaker, and I'm hopeful that some of you were able to, most of you, all of you, were able to attend her session on the 4th. That's Trauma-Informed Advocacy Strategy. She does the Trauma-Informed Lawyer podcast. And I like telling people about that because it's created by a lawyer. So it's sort of a window into certainly one lawyer, her, and then whoever her guests are, but it's a window into how the lens of lawyering and the lens of trauma-informed practice can come together. Oh, it was not one of the recorded sessions. Well, if you missed it, you missed it, but check out her podcast. I think that's Sarah sending me those messages, right? Yeah, thank you. Okay, so we're going to do breakout session number 1. We're going to see how it goes, everybody. We've got a scenario here. You attend a meeting with your client and their lawyer. The lawyer shares they've done a full review of the director's disclosure and their file notes and all the supportive materials that you and the client have provided to them. You all go over the history of the court case. The client's interactions with the MCFD began some years ago. Before the end of the meeting, the lawyer shares that their best legal advice, based on all of the above, to the client is to consent to a continuing care order, so a permanent order terminating their guardianship rights to their kids. So the discussion topics are, in what ways can you advocate for the client in the situation while you're together with the lawyer? How can you advocate for them following the meeting? And consider, what could the lawyer do? And so I'm asking for suggestions for lawyers, really. What could the lawyer do to increase the client's feeling of safety in the meeting? What could you do? And what could the lawyer do to build trust with the client? So I'm not asking you to do emotional labor, truly. I value your input, so please don't feel that this is a huge task. I think probably we'll do 5 minutes. And then if every group could, jot down a few in the chat box, we'll go over them once we're back, if that works. So Sarah, if you want to go for it.
Sure. I have.
Please do type, if you've got feedback from your group, please type it on into the chat. Otherwise, I was in a smaller group, but I feel that we had a good discussion. Points were made about how it seemed like the lawyer was making the decision for the client, and how there were certainly more options available than consenting to a CCO, but they weren't presented, and that was a very good observation. And how, it's certainly disappointing when lawyers get to the point where either they're presenting one option like it's the only option when it's not, or certainly if the lawyer needed to provide more explanation to make it clearer what, right? If a client is leaving a meeting and they don't understand why consent to a CCO was the option that was given, or rather the advice that was given by the lawyer, that's a very good opportunity for the advocate to circle back around and let the lawyer know, why the client doesn't understand why this is the only option. And certainly more information can be provided anytime. And occasionally, yes, my advice to my clients is, on occasion, consent to a CCO. Don't like doing it. Least favorite part of my job is giving that advice. But anytime I do give it, I make it very clear why this is the reason, or why this is the advice I'm giving. Okay. Then we've got someone else. So hello. We talked about transparency and why the lawyer wanted to go that route, about ways the parent might still be able to be involved in their kids' lives, such as contact, depending on the situation. Oh, certainly. Yeah. And talking about, exploring other options, exploring other placements. Sometimes family won't come forward at first. Oh, someone else says, even if consenting to a CCO, make sure the child has some input or the client has some input into their child's living arrangements. Thank you. Yes, you read my mind a little bit. I was just going to say, sometimes a family won't come forward at first because they don't want to be involved. They don't want the hassle of putting their names forward. They don't want to, deal with record checks, criminal record check, social work, or MCFD record check. But when they get to the point of a CCO being on the table, they go, oh, well, if it's really the last option and the kids can't be with their parents, then okay, I'll put my name forward. And oftentimes it can be the client going, okay, well, let me talk to so-and-so, let me talk to auntie, let me talk to, whoever. Let's see if family friend, let's see if we can't expand the group. Okay. I think that's all we've got here. So thank you, everyone.